Lord, anything on merits, at least his bail, etc., and it can be decided by the court. So he has no fear of going in. And my Lord,
I make a different suggestion, taking off.
So I thought this might be fair.
Yes,
I'm saying it as a counsel for the state. I think you should appreciate that. Not merit. Not fair at all. Either you confirm this order, I'm out into the We are not agreeing to this. I've been arguing. Yes. No, I'm telling my friends. Yeah, just me. No, I just put my shit in. Yeah, correct.
My Lord, may I make? I go with what my learned friend is saying to an extent. I'm only making this suggestion. Your Lordship on day one said that under 142, your Lordships could convert it into bail. Sorry. I don't think your Lordship's
mic is not working.
Volume is off, Lord. Either which way.
By February तक का डेट
My Lord, volume of mic either
Either
and my Lord the Chief Justice very
चल रही है
Lord, it shows it is on.
But just turn the mic to it, my Lord. Just turn the angle of the mic.
The entire system is...
Now it's fine.
Oh, now it's better. Now it's better.
We were adding only one thing small. That in case, because ultimately the regular
भाई
bill
अभी
is not
बातें चल
decided by
रही
the
है
High Court and you are on an
बात रख
interim
रहे हैं अभी
protection.
लोग
That protection will continue even beyond the final order that we passed by the High Court for a couple
जैसे
of
भाई
weeks
देख तो
to
बढ़िया से
enable
देख रहा हूँ
you to approach the...
But then your Lordship will keep the question of law open. Not my Lord, my learned friend wants it confirmed.
We'll come back.
And tomorrow, my Lord, I should be in an opportunity. The question of law should be kept open.
That's exactly.
Because otherwise, my Lords, what my learned friend is saying is, your Lordships are confirming the order of the High Court on an important issue of statutory bail as to whether or not such bail can be granted. My Lords, in a case where investigation is not complete and the charge sheet has not been taken cognizance of.
High Court's view, assuming SLP, dismissal of SLP is not confirmation.
Not that way. I'm only suggesting, my Lords, if your Lordships are saying apply for bail and in the event that you're not granted, the protection will continue, enable you to come back.
He wants to come back.
And the question of law be left open.
So there's a question of, as far as you are concerned, Lord, it is over.
That leads to multiple rounds
Again,
of
Lord,
litigation.
to all this.
We know that people can afford, but courts can't afford to have that one.
Then may I make one suggestion? Your Lordships under 142, day one, your Lordships indicated that. Please grant us the bail and dismiss the rest of the appeal as infructuous.
No, that's not.
That's all. End of the matter.
It can't be pakka bail, Lord, because you got default.
No,
bail.
that is not
I'm
fair.
making a concession. Treat him on interim bail. If I am going...
Well, they will have the right for cancellation.
With great difficulty, my Lord, I have told them...
No, they will have the right to ask for cancellation in that case.
That's not fair.
Once and forever.
Mr.
Well,
Natharaj,
Farah.
make sure our directions are meticulously complied with.
Yes, sir.
See, in some kind of illegal activities, unfortunately, in bigger, larger tracts of land, people will indulge. There are people who are incorrigibly involved in illegal mining, this and that. So you have to put your machinery there at this point, whatever mechanism you want to involve, but make sure that because illegal mining can lead to irreversible
Correct.
losses. And the consequences will be very devastating. And because in a regulated mining, one can understand that there is some regulator there, somebody
वेट करो
and
बताता
doing
हूँ
it.
मैं
But in this kind
थोड़ा
of
सा और देख
situation,
लूँ
illicit mining that has to be
बहुत
stopped.
सारे वकील है भाई
In any
बहुत
case,
सारे
this is
वकीलों
absolutely
बात
an
हो रही है
exercise
बहुत सारे
right,
वकील
and
अपना
nobody
अपना
should be
पक्ष
allowed
रख
to
रहे
do
हैं
it.
There is any
Can
particular
we give our application, Mullards? Can we give our application to the
There is any particular instance, let him bring it to my notice immediately.
There are other.
I am
we
giving.
are requesting to the members, don't file press writ petitions and IU to become. We know that why these writ petitions are being filed. We will not appreciate it. We have already taken so motto, we will take care of. But each one of you, Mr. Sibbal is also here. Welcome to assist the court.
Yeah, Malas, we want to assist. I file an intervention. Malas. It's very, Malas, going into the history of the Aravalis, Malas.
Mr. Sibbal, why we are
Science behind it.
Mr. Sibbal, why we are exactly? People will, now what will unfortunately happen? They will raise some kind of issues which will divert the main concentration of this. That's why we said it is not adversarial.
Absolutely.
You, all of you are with your experience and ability, welcome to assist us, but do not take it as that kind of.
Absolutely, Malas. And my intervention may be allowed, and Malas, I'll assist your lordship.
And you give your note to Mr. Sibbal also, and to other
Yeah,
central court
yeah.
also. And
We're here only to assist so that, Malas.
from the CEC side, you also do your homework and tell us what have been done and.
They've given their input. They've given their input.
CEC assists the amicus, Mullards. CEC assists the learned amicus. The CEC, Mullards, the Central Empowered Committee, Mr. Goel is here for CEC.
That's
They assist the learned amicus.
I know that.
Please.
I know that Mr. Goel, being member secretary of the CEC, will be assisting the amicus.
Yes, ma'am.
Now that in light of what we have observed on the last week in our order,
Yes, Mullards.
we need to have an expert team exclusively of the experts and experts from the different walks of life,
Yes, Mullards.
from the forest, from the other related issues will also arise. So you need to have a different kind of domain experts sitting together in under one umbrella.
Yes, ma'am.
And we would like all of you to suggest those names, so that we can constitute an independent expert committee.
Please.
Who will directly under the supervision and monitoring of this code will undertake the exercise stepwise.
Please, Mullards.
We'll do. We appreciate that.
Lordship, with your permission, I have
Your
to
lordship.
bring in your notice two important points.
Mr. Sharma, we will consider your two important
We
matters.
appreciate that. Malas. My request to your lordships is that while your lordships might wish to set up a board, please have a preliminary hearing, because it is our position in law that mountains cannot be defined. Himalayas cannot be defined, the Aravalis cannot be defined. There are subtectonic, Malas, strata, Malas, which moves from Gujarat right up to Uttar Pradesh, Malas. And therefore you can't, the problem is that you start defining Aravalis, Malas, you'll arrive at a problem. So please give us a preliminary hearing just for half an hour or 40 minutes. Just
No, hearing we will grant to everyone. There is no difficulty, but only where you find that the learned amicus has missed something, there we will
I will
welcome
support, we
anyone
will
to
support,
assist.
of course.
Where the union has missed anything, or where a very particular part or an issue has gone unnoticed from our side also.
We'll do that.
All of you will be most
Yes,
welcome
Malas,
to assist us on the matter.
actually.
Your lordships are permitting us to give our opinion to.
We will hear all of you, but
We'll suggest the names also, Malas.
Lordships, in fact, we welcome the suo motu order that's been passed. We have worked on the ground with farmers and affected communities, your lordships, and put together material with all geotags, photographs, etc. We want
all of you, we request that all of you can give that material to learn amicus so that there is no multiplicity, and with one through one channel, one office, you can have that entire material on record, and then we'll consider it. You write down. In reference to the order dated 29 December 2025, Mr. Surya Bhatti, Learned Addition Sources of India, has entered appearance on behalf of Union of India. Mr. K. M. Natral, Learned Addition Sources of India, represent the state of Rajasthan. We have Mr. Kameshwar, Learned Amicus, along with the member secretary of the CEC, is also present. We have impressed upon the learned amicus and other senior stroke counsels assisting in the matter that we take you to enable this court to take.
भाई मस्त दिन था आज 50-100 दे मारे कुछ कमाया या सिर्फ ब्रोकरेज में पैसा उड़ाया ब्रोकरेज
बुलाइए भाई अपने बैंक ऑफिसर को जस्ट रखे रहिए उसका अपने पास रखिए
सिर्फ एक बार फिर इसको देखने के लिए कि क्यों इनका अकाउंट में
आप कर कैसे आप अपना वो बताइए ना पावर्स क्या है आपके पास
सर जिस समय इनमें ये हुआ है
कितने साल तक आप रखेंगे किसी का बैंक अकाउंट फ्रीज आपके बताइए
इनको 2021 में सर बोला कि आप में
नहीं कर रहे कुछ भी नहीं कर रहे कितने साल तक legal activities. Next paragraph. The interim directions issued on 29 December 2025 shall continue to operate till further orders. Mr. Sibal, your application, which one?
Yes, so IA Malas 18034.
IA number 18034.
Code of 2020.
Here is the first one. Is allowed to extend the applicant is permitted to assist the court as an intervener. So rest of the applicants, whom I so advised, may approach the learned amicus and may contact the learned amicus and give their invaluable suggestions, stroke opinions to him to enable enable the learned amicus to place the same to enable the learned amicus to include those suggestions, stroke opinions in the comprehensive note that he has been requested to place on record. That post these matters after 4 weeks. Please, after 4 weeks on so and so date.
My lords, may I one subject? It's not a fresh matter. On a mentioning slip which had been filed with the registry, the matter on the forest, which is definition of forest, Ashok Kumar, item 32 had been listed with this.
We'll take separately.
But my lords, that may, because the issue of whether forest and what forest, we'll give the suggestions to the amicus.
We will take up separately.
But that may be taken along, listed along with this, as it was last.
Don't dictate us what to be done. We will do that. We are telling you.
My lords.
So our applications will
Your
Lordships, our applications may also be allowed, Your Lordships. We will assist.
What is item 32?
My lords, item 32 is that Ashok Kumar matter whether a direction of this court on how to identify forest lands.
We will see.
My lords, all I'm saying is that those.
Hundreds of matters are pending here.
Yes, no, my lords, I'm only talking about one thing. As far as Aravali is concerned, my lords, we'll of course put all the suggestions.
You file your counter, etc.
Sir, our applications are pending, my lords, because our facts are stated in our application.
Applications are slightly different. Your lordships, we will
No, please don't move any. If you will make unmanageable things for us, then we know the consequence.
Yes, but it's not, your
These
lordship,
applications, we know most of the applications why these are moved.
your
But
lordship.
don't ask us to take any, please wait, have patience, assist us in the matter.
Lordship. Lordship.
The item 32 list on separate date, you file your counter, etc.
Please, my lord.
And don't tag it with you.
No, my lords, at least because only from the forest point of view, my lords. That's why.
Forest point of view, we know what is forest point of view.
32 is a separate matter. They've challenged certain provisions of the
It's a separate matter.
It has to be taken as separate.
My lords, it does have a bearing on Aravali, my lord. That's
Thank
only
you very
reason
much.
why it is listed on a mentioning slip.
When we will consider forest, we will consider forest as a very wider term.
Yes,
Aravali will only be a component of it.
yes, exactly. But my lords, it would still be.
Please, it will be separated.
Grateful.
It will not be listed along.
Grateful.
Now, next item. Item 20.
Item 20 is the larger IAS you must put your notice. Item 20 is the, but 30 IAS are listed including zones on the TNG matter. Your lordship said put it on. Just before the vacation, your lordship said it will be put on a day when it can.
There is one
Plus there are about 30 IAS.
No, how many IAs have been listed?
About 30 IAS are there. But your lordship recollect, I circulated a larger note on eco-sensitive zones. There are today individual IAs and contempt petition. It will require some hearing. Your lordship will kindly put it on some other day because your lordships are only sitting till 1 o'clock in this combination.
My lord, there is one IA at item number 12 in this 21, my lord, where, my lord, this court has restrained us from proceeding further with the establishment of Aravali Zoo Safari. My lord, the application was filed on the premise that there is an issue already pending in this court with regard to a safari. But now in the rejoinder, they have admitted, and the judgment has also been given, that issue was with regard to tiger safari, not the zoo safari. So that judgment will not be applicable. Now, project is at very initial stage, my lord. We have submitted DPR to the Central Zoo Authority.
No. Where is your project? What is that project?
My lord, in the Aravali, my lord, in the Gurgaon region, Gurgaon Mewat region, there is a degraded forest, my lord, which has become degraded because of the mining. My lord, what we are proposing to set up a zoo safari there, my lord, it will, my lord, also help in the conservating the forest, as well as, my lord, some areas we have identified for the maintaining ponds also, my lord. So water conservation.
My lords,
also
this
there.
application
Now-
has been filed by us, my lords.
Yes.
My lords, this is 10,000 acres of forest land in the Aravalis, my lords, and there is no confusion on the definition here. It is
Right.
covered by my lords' orders.
Aravali definition can't be any confusion.
But right
My lord,
now, we are proceeding only with 3,500 acres,
My
not
lords, they are
10,000 acres.
misleading the court because they came last time and they said that we've redesigned the project. My lords, in our rejoinder, and my lords, I represent 5 former bureau forest officers, including officers of the Haryana cadre, my lords. This is prime forest land. It is degraded because of illegal mining, my lords. They are saying they need to develop a zoo safari, a tourism project to eco-restoral forest land.
No, Lord, it is by forest
Belongs to
department.
them.
My friend
The
is
land
wrong
is
saying.
forest land.
It is by forest department, and it is at very initial stage. We have submitted, kindly see, my lord, we have only submitted DPR to Central Zoo Authority. Central Zoo Authority is yet to consider that DPR, my lord.
Therefore, my lords, work.
Let Central Zoo Authority consider our DPR.
My lords, work cannot start till the DPR has
We are not starting work. It is only DPR we have submitted to see.
Not now any work to,
obliged.
no. What is the expert opinion? Has any expert opinion?
That has to be examined.
State might be having
Let
some
the CEC do it.
commercial interest or whatever it is. Why don't the CEC examine and?
Yes, my lord, we send it to CEC, my lord, we have no problem.
Because the project is such an inception stage, Milords, that even the identification of the land, according to me, needs to be considered whether you need a project of this nature at all. In fact, Milords, your lordships, instead of referring it to the CEC at this point of time, your lordships will hear this
No, we are,
one day.
Mr. Commissioner, we are confident about it that CEC as a court constituted for creation of this code will have an autonomous body and will give their opinion, expert opinion, as completely independent, free from their without identifying themselves as something as a government organ. So we expect that kind of opinion. And if there is something which is contrary to the environmental norms or against the existing laws, we expect them to be frank enough to tell us. Otherwise, we are not the experts.
Because there are three grave concerns, Manoj. One is the water table. One is the issue of what kind of species and what kind of afforestation they're planning to bring in, and where are they going to source the animals. All three are ecologically relevant.
CAC can consider all these aspects.
Minute, sir. I've not interrupted you. Please don't interrupt.
I'm sorry.
I'm only raising a concern before the court. So all these three concerns, Milords, at this stage, I think there is sufficient doubt to say that, Milords, this project may cause ecological damage. But I don't know whether CEC will be able to even appreciate this at this stage because they have not come forward with the entirety of the documents.
That's
One of the grave concerns raised in the application is, what is this project? What are you going to do with it?
That suppose tomorrow CEC says that no, this project can't be permitted. It will lead to further destruction. Matter ends.
That's right.
But suppose they say no, it can be done, but it can be done with certain conditions, with certain regulatory measures. Then again, there is no necessity for us to accept that report as such without having the assistance of you people.
Very well.
We can always hear you.
Very well.
My lords,
Only a
as long as
recommendation, Lord.
my lords, our only concern was that certain statements were made that work is starting. If work is not starting, my lords, we have no problem in this getting assessed.
Either they will start, nor we will permit them to start.
Certainly, Lord.
So no work should start is the only thing, my lords.
What is that? Is there any
It
idea?
is item number 12 in 21, my lord.
In 20, my lords.
Godavarman. Issue notice to CEC.
My lords, notice has been issued. We filed our rejoinder.
Easy is saying, just let it go.
It's
only a reference to
Able the CEC to submit its expert opinion, stroke report, to submit its expert report, to enable it to submit its opinion to an expert opinion to a report, which may be placed on record with advanced copy to learned advisors as well as to learned senior additional advocate general for the state of Haryana. However, the interim directions issued earlier shall continue to operate till further notice.
My lord, there is a contempt petition, my lord.
Lord, may I seek my Lord's indulgence? My Lord,
Wait.
item.
Wait,
Lord.
this is a problem online that you push your button anytime and then you interrupt.
My Lord, it's a Sukhna Lake matter I wanted to mention. It is in this very item.
कितना सुखाओगे उसको?
My Lord, because there were directions.
Illegal unauthorized construction in collusion and connivance with bureaucrats there in Chandigarh and some political entities in Punjab. The lake has been completely at the verge of destruction. Who are the builder mafia operating?
I have not been searched.
We don't know how they. At least this much people have the management. Yes, please.
Lord, I'm going out for some personal family function today. But there are 4 matters coming up, group of 4 matters against the same order on Friday. Lord, my learned friend appears, my Lord, subject to your Lordship's approval. Somebody would mention, Lord, if it can go next week, my Lord.
Both sides are.
Yes.
I don't know.
Friday may be better.
Even Friday next, my Lord, would be.
That is, it is coming this Friday. It could be good the next Friday.
We will try to resist.
It's item 11 this Friday.
Well,
I'm obliged. Grateful.
With my lord's kind permission, may I please mention with matter, my lords. My lords, there is some grave urgency in this matter, my lords, because the elections with respect to the municipality, my lords, are to be notified on 27th of, my lords, that would be Tuesday. And my lords, prior to that, there's a weekend and 26th of January. If the matter is not heard at the earliest, my lords, I would be rendered remediless. My lords,
there is no question of
my lords, the notification.
How are you rendered remediless?
Yes, my lord. My lords, I have challenged the notifications with respect to wherein in giving a complete go-by to the constitutional provisions, section 243Q and 243T, my lords, some categorization has been done with respect to the 9 municipal corporations, my lords, which is not permitted in the constitution, my lords.
So if
Because-
your challenge is ultimately accepted, the election will be set aside.
My lords,
Election will go, fresh election will take place.
my lords, I have already challenged these notification and the subsequent notification, my lords, and those two notifications.
Therefore, as and when, suppose the election is held tomorrow and your petition is allowed up to 6 months, the election will be set aside. There will be a fresh election and you will contest for it.
My lords, what
Where
is
the
my
question of being remediless?
My lords, my difficulty today is, my lords, that I have already approached the Honorable High Court at a very prior date, my lords. The High Court, my lords, have heard the matter and not passed any interim order, and the matter is pending for the judgment, my lord.
Thank you. There is
But I'm just requesting if it could be heard, my lords, because it is
Monday, 2 days will be on Monday.
Monday. Obliged.
Subject to curing the defects.
Yes, madam.
My lords, if I may request for urgent mentioning, these are students who are in their second year of the homeopathy course, my lords, and their admission has been cancelled and they have been stopped from sitting in the exams on the ground.
Why there must be some good reason.
On the ground that, my lords, at the time the admission was made, they were not NEET qualified. Similar candidates by this court has been granted relief, my lords, and that matter is coming up next week. I'm only requesting, my lords, if it can come up with that matter, my lords.
It will be. Again, make sure that no defect.
My lords, I'm deeply obliged.
Item 1.
It's an application for early hearing, but the appellant has undergone 15 years.
There are 7 early hearings. We'll fix some date in all the matter.
Just that he's undergone 15 years here.
But if I start giving date, then same thing will happen. So I will have to see the management. Yes, let's start from item 8.
Serial number 7.
Item 7.
Serial number 7, which is the early hearing, the Lordship has passed an order. There's also a IA which is reflected for withdrawal of the amount, my lords, which is already deposited. It's a land acquisition matter. That is reflected in the office report.
We will list it because
Please, this matter, lords, it concerns the identity of the petitioner.
But we have dismissed the SLP, so we file a report.
While dismissing at page 213, my lord, my lords had given liberty, my lord.
To the same court.
At page 213, my lord.
That is the High Court, not the
Lords have
Supreme Court.
observed, my lord. May I show my lords, my lords? Page 213 is the order, my lord. Lords, may I read it, my lords? Lords, what is happening? My lords,
Propose the for an appropriate application. No, it's maintainability. Next.
lords, have disposed.
This will be liberty to go to High Court with an appropriate application. You have to file a review application before the High Court. Nothing can be done.
What I'm saying is, notes, those proceedings were under the election. I'm not challenging the election part, notes. What has now happened, it concerns my identity itself, notes.
For that you go to yes, High Court.
Review remedy, notes, in the rate of.
We are not inclined to entertain the petition. The same is according to this case. Our petition shall be at liberty to approve the High Court, provided that she pleads a fresh cause of action.
Notes, may kindly permit me to withdraw them because a lot of questions are raised in this regarding my caste status. Notes, dismissal will.
Knowledge then dismissal withdrawn will be taken.
Very
Next item 9.
All grounds may be open.
Thank you.
9 is covered by good third.
Oh.
Has to be given retrospective. They are cutting it at 96.
So they are not to be given retrospectively. Yes, we are in item 9.
For the
Item
period,
9.
my lord, 9.4.
My lords, learned ASG is leading the matter. I'm requesting a short pass over.
Yes. All citizens to bring. Item 10.
So, Lordship, my colleague is supposed to have joined, but this is.
I am appearing, Lords.
Yes, please.
There is a similar order passed out of the same impugned order. 2 matters were filed. Your Lordships have been pleased to issue notice and another SLP on number.
Same issue for notice.
Yes, first order.
With SLP civil number 736175/2025. What is the next date?
Was that is showing in March, 15th or something?
9th March.
9th March.
Lords, we are also praying for stay of the demand notices to them in item 10, stay of the.
Was there any stay in the other matter? Also?
Yes, my lords, but in our case, the demand notice is already issued.
All in terms to in same terms. Same in terms to.
My lords.
Item 11.
Hey, please.
Exactly, sir. Exactly. This is the order. Not challenging. This is the order after that. 169.
Maharaj, I am the successful resolution applicant. I resolved the company by payout of 411 crores. And then I'm saddled with another 192 crores on behalf of a person who files a claim as an operational creditor is given a notional value of 1, and your lordships and SR downwards have held notional values can be given, and all that the OC has to be paid according to the Act is above the liquidation value. The liquidation value is nil here. So even if I were not to give a notional value, the maximum that they could have got is 22,000 rupees because they can't get more than any other operational creditor. Now, merely because they started an arbitration in advance, your lodges and Electro Steel downwards have held that even if an arbitration was started in advance and no 34 is filed challenging the award, even in the execution of that award, the plea can be taken that the arbitral jurisdiction.
Arbitration was already pending. Whether you stand
Those are cases where the award had not been put up as a claim in the resolution plan. This is a contingent claim in the resolution.
And it's contingent.
So the impact of a contingent claim has to be decided by the arbiter.
My lord, so lodges have time and again said, contingent claims can be given a notional value of 1 and any claim prior in time stands extinguished in view of the overriding provision of the IBC. So my lords, that's not with utmost respect. It's not on any demand which was prior in time and contingent, including in Ghansham. Your lordships have entertained Article 32 petitions directly.
SR is distinguishable.
No, my lords, SR is one part.
SR is distinguishable, sir.
I'm not on, I did not even cite SR. I'm saying from Ghansham.
So
now,
Mr. Paul, if SR is distinguishable, then let this issue be decided by the arbitrator.
No, my arbitral award has been given now 192 crores.
Oh, it has been given.
They've given an 192 crore award. Place that by way of an additional affidavit before your lordships.
You have to challenge that.
My lords, may I with respect say in Electro Steel, your lordships may just hear me for 2 minutes, my lords. Electro Steel, there was no challenge to the award. At the execution stage, the Supreme
Date of the award.
Please, my lords.
What is the date of the award?
My lords, may I with respect say the date of the award is December.
19th December.
19 December.
19th December, he has filed the SLP on 8th.
It's 23rd December, received on 28th December. My lords, may I with respect say 2 things. In Ghansham, I had the privilege of assisting this court. Your lordships entertained direct 32 petitions because authorities on contingent claims are going on with their demands. Please, my lords.
We will not do so now.
No, my lords, may I with respect say lordships may not do it a 32. This is not a 32. This is not a 32.
437.
Article 136 is now infructuous.
No, my lords, may I with
Because of the award.
my lords, may I with respect say, I am on the fact that no extension ought to have been given. If that extension is held to be invalid, then no award could have been passed.
That we do not agree with.
My lords, may I with respect say one thing? Then there is also a delay in this. Would your lordships leave it open for me to raise all my objections on the execution petition as and when is filed?
Execution, you are now probably you have to get 34 or 30.
My lords, that your lordships have held.
Right.
Contingent claims will be settled at rupees 1.
What?
Yeah, I know.
My lords, may I with respect say two things, My lords, just keep two things in mind. Electro steel, there was no 34 filed. My lords, may I only make one submission and then your lordships could pass the order?
Has already passed the award in December 2025. In that view of the matter, the instant special deputation is rendered infructuous. The same is disposed of, our granting liberty to deputation to raise all the contentions before appropriate forum.
My lords, may I only make, I know your lordships have dictated the order, may I only say one thing? My lords, one, notional values have been upheld by your lordships, that's one. But more importantly, in electro steel, where no challenge was made under a 34, even in an execution, your lordship said that the court ought not to have executed the award because the arbitral tribunal cannot and could not have ruled on it because the substratum of the claim had disappeared. That's all that I am bringing to your lordship's notice.
That award is not under challenge before us, so we can't give any such.
Very well, my lords have given me the liberty to raise all objections in the appropriate.
So that
Yes.
before appropriate.
My lords, would your lordships condone the delay, my lords, in filing?
Yes.
Grateful.
Very grateful.
My lord, this is a case, my lords, for a civil judge junior division, recruitment of civil judge junior division, my lords. I must. No, my lords, can you three things. My lords, I'm a second ranker in this. I'm a gold medalist throughout, second ranker in this exam.
We appreciate your hardship, we are burning also. In fact, we understand your another predicament also, that because you are a 2023 grad.
Yes.
Now, unfortunately, because of 3-year condition, you will be able to.
That's right.
We understand, but then what, we can't change.
But
the law.
arbitrarily, my lord, may I just suggest a solution, my lord? Just look at the way here. My lord, first of all, minimum criteria for viva voce. She loses out not on her written exam, where she's a second ranker.
This condition of 50% is not something that any rule of the game has been changed. This was there in 24, this is there in 25. It is well advertised in the advertisement.
My lord, there are no rules prescribing a minimum qualification. It comes by way of notification, and it comes for the first time in 2024. My lord, the notification for the first time in 2024 brings out this minimum qualification. And I get to know of it after this judgment of 3-year qualifications filed, that because of viva voce, I'm moved out. Now, my lord, one more aspect here is this, that there is in the category of general, I'm an open reserve category, there's a place kept for women which was not filled up last year. That is taken over this year. So, my lord, viva voce has been
concerned about DG please.
No, my lord, the only thing is that the viva voce.
Let's not waste time on this.
Wait, please, my lords. My lords, the clauses at page 192, 193 are in the teeth of 3 direct judgments of your lordships. The IOCL decides whom to appoint out of their own panel. This has been covered by a constitutional bench in 2 judgments of your lordships. What is worse, they say you can't go to arbitration till I allow you to accept it as a notified claim. They will accept and only then you can go to arbitration. Notice.
So I appear in the connected 2 matters.
Deeply obliged. Much more.
You know, this was a commercial auction by state of Punjab. I have paid money. There are trees, you know, I have taken permission. We have to pay and I have plant 10 times more. I have done all that. The High Court granted.
But matter is pending in the High Court.
Problem is this, I knew Milord Lordship will say that.
No,
now the problem.
We can only request the High Court to decide earlier.
I agree. Only one thing. The High Court has tagged all the PILs in the state of Punjab with my case. All of them. That's the second order. So now, my lord, every time it comes last time it came at 5 o'clock.
Cited Mohinder Singh Gill also and AP Hill Leaders Conference to substantiate not that Article 324 is a comprehensive function in power, Lord, which involves administrative, adjudicatory as well as legislative. And in that context, note that SIR in issue is legislative in character. Now, there are 3 judgments which are not on record. I will not read them, I'll just indicate the paragraphs where the lordships have said that what is legislative character. So if the orders are of a general character, applying to the entirety of constituencies as in this case, and are not deciding any particular case. This is 1987 2 SCC 720, Union of India versus Cyanamide. The Lordship may just note at the top colors, paragraph 4 to 7, 13, 14, and 27 of cyanamide.
13, 14, and 25.
27. 4 to 7, 13, 14, and 27. The second case is Shri Sitaram Sugar, Constitution Bench, paragraph, that's 1990, volume 3, SCC 223, para 31, 35, and 37.
Please tell the paragraphs again, Mr.
31, para 31, 35, and 37. The third is 2002, volume 2, SCC, page 7, State of Punjab versus Tehal Singh, that's paragraph 6. The first two are in the context of price control orders issued under Essential Commodities Act, Section 3. And the third one is in the context of a notification for establishment of Gram Sabha areas under the Panchayat and Zilla Parishad Act.
Delimitation.
Not delimitation, but establishment of Gram Sabha, not in the context of election. And this cyanamide has been followed, the Constitution Bench has approved. So Lordship has just one paragraph of cyanamide. I will not read the other ones. The third observation we wish to make is price fixation is more in the nature of legislative activity than any other. It is true that with the proliferation of delegated legislation, there is a tendency for the line between legislation and administration to vanish into an illusion. Administrative quasi-judicial decisions tend to merge in legislative activity, and conversely, legislative activity tends to fade into and present an appearance of an administrative or quasi-judicial activity. Any attempt to draw a distinct line between the legislative and administrative function is difficult in theory and impossible in practice. Though difficult, it is necessary. I am relying on this portion, that the line must sometimes be drawn as different legal rights and consequences may issue. The distinction between the two has usually been expressed as one between the general and the particular. A legislative act is the creation and promulgation of a general rule of conduct without reference to particular cases. An administrative act is the making an issue of a specific direction of the application of general rule to a particular case in accordance with the requirements of policy. Legislation is the process of formulating a general rule of conduct without reference to particular cases and usually operating in future. Administration is the process of performing particular acts, of issuing particular orders or making decisions which apply general rules to particular cases. It has also been said rule-making is normally directed towards the formulation of requirements having a general application to all members of a broadly identifiable class. So that is sufficient words for my purposes. So relying on these three judgments, in support of my submission that the SIR order is in legislative character, why I am doing so is, my Lord, becomes significant when the Lordship will examine, my Lord, when I come to section 21.3, which says recording of reasons. So So the recording of reasons, my lord, when an administrative order is issued, deciding having a civil consequence, or an administrative order, my lord, which is or a quasi judicial order, or a judicatory order. So the reasons in a judgment are of a different kind. But when if the order is of a legislative character, not it would be somewhat something akin to. I am not trying at all to equate the authority of the election commission with parliament. No. Parliament is a different organ, supreme organ in legislation making under 245, 246. I do not have that power. I don't claim that power. But nevertheless, as Mohinder Singh Gill says, that 324 is plenary. Now, if an SIR is issued under 324, read with section 21.3 or other enabling powers, then that is not legislative in character, and the reasons will be somewhat akin to that. What I have to indicate under 21.3 is why am I holding this special revision? It has nothing to do, there is no list involved when I issue an SIR. The normal procedure of summary, etc. is prescribed, the rules are there. All of them contemplate a deviation. So why am I deviating? So the reason has to have a nexus with that and that alone. And that can't be something akin not to adjudication or an administrative order which decides somebody's rights. So it's for that purpose, limited purpose, not that this I have. So the third judgment which was relied upon by the petitioners was A.C. Jose versus Sivan Pillai. That is 1984 2 STC 656. Now this was a case, my lord, where my lords, the rules prescribed that the voting should be done by ballot papers. But it was decided by the election commission that we will experiment before introducing this EVMs throughout all constituencies all over the country. We will first experiment in few constituencies. That was challenged. The rule had not been amended. The election commission had gone to the government of India for permission. The government of India had refused. Yet, not that order had been issued for experimentation. It is in this context that this judgment was rendered. In paragraph 5, the arguments have been noted, Lords, and I have some judgments noted in paragraph 11. It's paragraph 20, kindly come to para 20. We fully endorse and follow the above observations of the Constitution Bench, which lay down the correct law on the subject, and we have nothing further to add to the approach made by this court in the case referred to above. On the other hand, our view, Article 324 to 329 have to be construed harmoniously, flows as a logical corollary on the ratio in Punuswami's case. The pointed observations extracted above really amount to a Bible of the election law as culled out from an interpretation of the provisions of 324 to 329 of the Constitution, and we are referred to with approval even in Mohinder Singh Gill. During the last 3 decades, this case has neither been distinguished nor dissented from and still holds the field, and with due respect, very rightly. No other case has ever been made such a dynamic and clear approach to the problem, and perhaps due to the fact that no such decision arose before, the Commission has always been following the provisions of the Act and the rules and had never attempted to arrogate to itself powers which were not meant to belong to it. Indeed, if we were to accept the contention of the respondents, it would convert the Commission into an absolute despot in the field of elections so as to give directions regarding the mode and manner of elections, bypassing the provisions of Act and rules, purported to exercise powers under cover of 324. If the commission is armed with such unlimited arbitrary powers, and if it ever happens that this person manning the commission shares or is wedded to a particular ideology, he could, by giving odd directions, cause a political havoc or bring about constitutional crisis, setting at naught the integrity and independence of the electoral process, so important and indispensable. Further, such an absolute and uncanalized power given to commission without providing any guidelines would itself destroy the basic structure of the rule of law. It is manifest that such a disastrous consequence could never have been contemplated by the constitution makers, for such an interpretation as suggested by the counsel for the respondent would be far from attaining the goal or purity and sanctity of the electoral process. Hence, we must construe Article 324 to 329 as an integral part of the same scheme, collaborating rather than colliding with one another. Kindly mark this, brother. Even I submitted, brother, that they are in a symbiotic relationship. Moreover, a perusal of Article 324, 329 would reveal that the legislative powers in respect of matters relating to Parliament or state legislatures vest in Parliament and in no other body. Commission would come into picture only if no provision has been made by Parliament in regard to the elections to Parliament or state legislatures. Furthermore, the power under Article 324 relating to superintendent's direction and control was actually vesting of merely all the executive powers and not the legislative. Kindly mark this sentence, first. This is running contrary to Vinder Singh Gill, which said that all three powers, including legislative, are there. This, and their lordships have not noticed one of the symbols cases which I have cited, Sadiq Ali and all in. In other words, the legislative power of Parliament or the legislature, of course, I don't legislate in the same sense as the Parliament. We don't do that. And probably it is that which their lordships have in mind when they say that not the legislative powers. In other words, the legislative power of Parliament or of legislature of state being made subject to 324 only means that no law made by Parliament under 327 or by state legislature under 328 can take away or deprive the commission of the executive power in regard to matters entrusted to it with superintendent's direction and control of election. This again is not accurate, blood, and militates with the other judgments. Now, please have paragraph 26. The particular provision which was an issue. Manner of voting at elections, section 59, that's quoted. At every election where a poll is taken, votes shall be taken by ballot in such manner as be prescribed, and no votes shall be received by proxy. So a specific, exhaustive, the rule is of an exhaustive character. That you will have a poll based on ballot papers. And since there was a deviation, and that is what emphasized in 27, it is obvious that section 59 uses the words ballot in such manner as may be prescribed, and prescribed means by rules, which means prescribed by rules made under the Act. A reference to section 61 would show that Parliament intended use of ballot paper only for casting of votes. This takes us to Rule 49, the relevant part of which is extracted. Notwithstanding anything contained in preceding provisions of this part, the Election Commission may, by notification published in the Gazette at least 15 days before the date or the first of the dates the poll appointed for an election, direct the method of voting by ballot shall be followed. So in para 29, the court concludes that on a proper and detailed analysis of these rules, it is clear that by framing the rules completely excluded the mechanical process. So if your lordship comes to the conclusion that this SIR order is kind of this nature of order is completely excluded, and I'm emphasizing completely excluded. If there is no complete exclusion, no exhaustive enumeration, then the Lord 324, etc. is not ousted. And JOS is of no assistance to the petitioner's submission. It has no bearing to the nature of exercise which we are conducting. If your lordship has page 12 of my written submission, I will not read these cases. These are all on the symbols order. 4 cases have been cited, where paragraphs have been mentioned. All of which show, my lord, that 324 includes such a power. And it was upheld because the rules permitted, the symbols rules, rule 5 and 10 of the conduct rules, they contemplated that election commission will prescribe. Now, Anup Barnawal, because I am not going into detail because I am not contesting the formulation that the right of an elector to be registered and by necessary implication to vote is a constitutional right. But it is dependent upon the fulfillment of the 3 conditions. And this case, in any way, Lord, was concerned with how the election commissioner, CEC, will be appointed. And that ultimately certain directions were issued, some act has been amended, which again is before challenge in this court. So I submit, Lord, in paragraph 6 at page 13 that the fundamental error committed by the petitioners is that they are picking up judgments and applying them like a mathematical formula. Dehorse the factual, the background of that in which the issues arose there, and dehorse the rules, etc., which were under consideration. And those cases, again, Lord, I need not read, that's well settled, Lord, in this. I mentioned the judgments there, paragraph 6. Part 3, Lord. Section 3 is paise, Euro. Now at page 17, I have specifically dealt with probative value. If the lordship grants me the indulgence, my lord, the heading may be corrected slightly by saying adequate probative value, because that's the expression which Lal Babu's case. I have already made my submission, my lord, that why, my lord, our SIR provides adequate probative value. And in particular, para 15 may be noted where I have mentioned, my lord, that the earlier previous SIRs were conducted, and that was the context in which Lal Babu was rendered. Now, my lords, if I may come to the statutory provisions, the next part of the submission. Kindly have the Representation of People Act. Kindly have the Representation of People Act.